excellent presentations. I think we have time for a few questions here from our attendees. Again, you can still utilize that chat window if you need to. And I want to go to Désirée. I want to start with you, but Kyle and Shreya, feel free to chime in as well on the answers to this also. But can we go back to comparable market principle? How is that interpreted in terms of license agreement termination? Désirée, can we start with you on that? Just make sure Désirée is not muted. Okay, there we go. Okay.
I'm here. That's exactly what I was having. Yes, we in Germany if we go for the comparative market principle, we indeed look at the entity, at its size, at its turnover that is generated, and so on, and look what has happened for similar entities. So what you do is you look at the comparative market. So try to find entities that are similar. Of course, there will always be a first one, but typically, and you try amongst this similar entities, you try to find a similar front rate. Of course, these may still deviate a little, but these these entities are then a good guidepost for determining the front rate for this particular entity then.
Excellent. Any thoughts from Kyle or Shreya?
None from me.
I think I'd just like to add that, a comparator, there is sound finance of economic principles that support this concept of, using comparators. Indeed, for instance, in financial valuation, the multiples-based method is around the law of one price, that similar products should have similar, their prices should converge. There is also, to me, the particular attraction of it being market-tested evidence. So it is actual evidence on, what licensees are willing to pay in commercially negotiated contracts, which is, again, one of the key principles of how to determine FRAND.
Excellent.
And I'll pause there.
All right. I want to go to Kyle, a question for you again, if we could talk a little bit more about SEP licensing. What are the benefits of component-level SEP licensing? Again, we'll start with Kyle. Désirée, Shreya, feel free to respond also. Kyle?
So, from an end product manufacturer's point of view, typically they want to be able to purchase fully licensed components. So, for them, it would be a boon. For example, IoT startups with tight budgets are typically not equipped to handle SEP licensing. They won't have, in-house counsel or probably out-house counsel that's, experienced in these very particular type of negotiations, and will typically require indemnification from component manufacturers. So if the component manufacturers are the in payer, it makes things a little bit simpler in certain situations, but for car makers, the argument's a little bit different. They have a bigger budget, so you can't really feel as bad for them as needing to hire an SEP attorney to handle this and figure out, because there's such little guidance technically out there, and you need to be appraised of so much, it could be a barrier to entry if these IoT startups aren't able to get indemnifications where they could basically not worry about it at all. Whereas with the car makers, it's more that they're just really far from this industry of internet connectivity, right? Not every car a car maker makes is going to be a smart car, and most of the parts that go in the car are not going to be anything to do with internet connectivity, right? It's not like the analogy of what's the worth of a phone versus a smartphone, right? Nowadays, a car is still a car when you take the internet connectivity out. So, there is some complex economics into, figuring out, well, what's someone willing to pay for a smart car versus a not smart car, I guess is one issue. But, for the car maker, they kind of consider this such a small portion of their product. From the component manufacturer side, who typically may have indemnification requirements, they're going to prefer that they're able to just go and acquire those licenses themselves to meet, expectations of their customers. If you are, sorry.
Go ahead.
And then so if and there's some, situations where you could see if I'm basing the royalty off of, a car, a Mercedes-Benz, I don't know, real expensive unit, you can see how what the patent owner is going to be asking from is going to be a lot higher than what the component itself costs. So, we're at this situation where, if there is some added benefit that can't be captured at the component level, who is supposed to lose on that issue? That I think that's the problem here. And so for the SEP owner, the only real benefit I would think is simplicity if it's that case, right? We talked about I believe there's more automotive makers than chip makers, right? But then if it is true that there's some additional benefit, right, that can't be captured at the component level, then it would seem there would be some downside to SEP owners. But as we already talked about, there is a cap at being able to not try and collect royalties on things that aren't related to your SEPs. But it's not an open question. So some people would benefit. There may be some benefit to SEP owner, but I think we're at a point where people are really on opposite sides of this. So I'm not sure how we solve this,